Hello everyone. Today we are going to discuss Article 13 of the Indian Constitution, a provision often called the cornerstone of fundamental rights. If you understand Article 13 properly, you automatically understand how courts control the legislative power in India, why some laws survive while others are struck down, and how doctrines like severability, eclipse, waiver, and prospective overruling came into existence. So let's begin. So now let's talk about the structure of Article 13. So 13 clause 1 says that all laws in force before 26 January 1950 shall be void to the extent that they are inconsistent with the fundamental right. Now here the key phrase that you need to keep in mind is that to the extent of inconsistency. This means that old laws are not automatically repealed. Only the inconsistent portion becomes inoperative. That means that the laws that have now become inconsistent with the enactment of the Constitution. So, when the Constitution came into existence, if there was any law that was existence prior to the enactment of the Constitution, and if it is found that the provision of those laws are inconsistent with any of the provisions of the Constitution which has been enacted and adopted, then only the inconsistent portion becomes inoperative. Article 13 clause 2 talks about post-constitutional laws. It states that the state shall not make any law which takes away or abridges fundamental rights. So now here you have to keep in mind, earlier we were talking about the laws that were in existence prior to the enactment of the Constitution, and now we are talking about those laws that will be framed once the Constitution has been adopted. So, if any law is made after the enactment of the Constitution and it is found that it is inconsistent with any of the provisions of the Indian Constitution, then that law is void from the very beginning. Then we have Article 13 clause 3, which talks about the meaning of law. So, the Constitution gives a very wide meaning to the term law. On a cursory look, we can say that law includes ordinances, rules and regulations, bylaws, notifications, customs and usages having the force of law. So, even the customs can be tested on the touchstone of fundamental rights. Next, we come to Article 13 clause 4, which talks about constitutional amendments. Now, this was inserted by the 24th Constitutional Amendment 1971. It clarifies that Article 13 does not apply to constitutional amendments made under Article 368. But remember, this power is limited by the basic structure doctrine. The basic structure doctrine states that any amendments can be made, but any amendment so made cannot destroy the basic structure of the Constitution. And what is the basic structure has been defined by the courts in numerous cases. So we can say again that the amendments that are made under Article 368 do not come under the definition of law as per Article 13 clause 4, but any so amendments made can also not destroy the basic structure of the Indian Constitution. So now you can relate Article 13 clause 2, which says that any law made in the post-constitutional era cannot destroy the fundamental rights. You can relate now these 2 points and study. Now let us understand the judicial doctrines evolved to apply Article 13 pragmatically over the years. So foremost we are going to talk about doctrine of severability. Now, the doctrine of severability means that if only a part of a law violates the fundamental rights, then only that part or portion is struck down and not the entire law. The key case on this point was A.K. Gopalan versus State of Madras. Now, what are the tests applied under this doctrine? So, under this doctrine, to study whether a portion is valid or not, or void, we understand it by applying certain tests, and these are: the court sees that can a valid part stand independently, means when a part of the law is valid and the other part is not valid, then can the two be separated? The second questions or the test that the court applies is that did the legislature intend that the valid part to operate alone? So that means the legislature, while making such law, did they have this intention that if the non-valid or the void portion of the law is segregated, separated from the main portion, then can that valid portion have its independent existence? Now, let us understand this with an example. Suppose if section 3 of a particular law violates article 19, but sections 1, 2 and 4 of the same law are independent and valid, then only section 3 is invalidated and the rest of the sections, that is 1, 2 and 4, can be carried on. They can remain in force as they are. So, now here keep one thing in mind. Whenever you write about doctrine of severability, never forget to mention the entire phrase, that is void to the extent of inconsistency, while explaining the doctrine of severability. Next, we are going to discuss about doctrine of eclipse. Now, doctrine of eclipse applies only to pre-constitutional laws that are inconsistent with the fundamental rights. And these laws which are inconsistent and pre-constitutional, these are provided under, remember, Article 13, Clause 1. So now, as per the doctrine of eclipse, any law that was enacted during the pre-constitutional era and is inconsistent with the fundamental rights after the constitution has been enacted, then that law is not dead. It remains dormant. It is now only overshadowed or eclipsed by the constitution. The key case under this doctrine is Bikaji versus State of Madhya Pradesh. Now, few important points that you must keep in mind while studying doctrine of eclipse. Number one, it applies only and only to pre-constitutional laws. The laws become unenforceable only and only against the citizens. And if the relevant fundamental right is later amended, then the law revives automatically. Now understand this point. Suppose a fundamental right was brought into existence with the enactment of the constitution, and as per doctrine of eclipse, there was a pre-constitutional law which now becomes inconsistent with these fundamental rights. So, as per doctrine of eclipse, it will remain dormant or overshadowed by the provisions of the constitution. But if the same fundamental right later is amended, and as per the amendment brought in, the law that was inconsistent and was eclipsed, if anyhow it becomes relevant with the fundamental right or consistent with the now amended fundamental right, then it revives automatically. So, this was doctrine of eclipse under Article 13. The question of waiver of fundamental rights arose in the case of Basheshwar Nath versus Income Tax Commissioner for the first time. Now, it was held that the doctrine of waiver is not applicable to Part 3 of the Indian Constitution as it is applied to the American Constitution. Thus, no citizen can waive or give up his fundamental rights that are guaranteed to him under Part 3 of the Indian Constitution, as it is not only his right but at the same time, it also imposes an obligation to the state. Therefore, fundamental rights under the doctrine of waiver cannot be waived. Next, we come to the doctrine of prospective overruling. This means that the Supreme Court can declare a law unconstitutional, but at the same time apply the decision only to future cases. As the name suggests, prospective overruling. So, in future cases, we are applying the decision though the law has been declared unconstitutional. The key case on this doctrine is Golaknath versus State of Punjab. So, what is the purpose of this doctrine? The basic purpose which this doctrine serves is that it avoids legal chaos, it protects the past transactions, whatever has been done, whatever has been decided, it is done with it. And next, balance justice with certainty. So, whatever was decided in the past, it remains unconstitutional or it remains as it is, but in future we are going to work in a better manner with the keeping in mind the Constitution of India. So now link with Article 13. It softens the harsh effect of declaring laws void under Article 13. So it only declares them unconstitutional, but it works keeping in mind the prospective aspects of the cases, the future aspects of the cases. Next, we come to a very important doctrine, the doctrine of judicial review. Now, Article 13 empowers the courts to examine and invalidate laws that violate the fundamental rights. And the key case on this point is Minerva Mills versus Union of India. So, what is the significance or importance of judicial review? Now, there are few points that you must keep in mind. Number one, judicial review is the part of basic structure of the Indian Constitution. Now, what is basic structure? See, every time there is a change made in the Constitution, and such changes are called amendments. So, every time the Parliament brings about an amendment in the Constitution, they can do so, but they cannot touch the basic structure. They cannot destroy the basic structure of the Constitution. So, what constitutes the basic structure of the Constitution? There are certain principles, certain concepts that have been recognized by the courts over the period of time that cannot be touched by amendments. So, these doctrines are those doctrines that help us preserving the basic concepts, the basic principles enshrined in the Constitution. They help us in keeping the Constitution intact. So, all these concepts that cannot be destroyed through the amendments are termed as the basic structure of the Indian Constitution. And thus, we have the theory of the basic structure theory of the Indian Constitution. So, even the Parliament cannot remove the doctrine of judicial review through amendments. So, that's why we have the concept of judicial review. In very simple terms, we can say that any amendments that are brought in the Constitution which violate the fundamental rights of a citizen, the courts, through the power of judicial review, can declare them void and unconstitutional if they violate or hamper the fundamental rights. And this part through which the courts declare the rights, the laws violative of fundamental rights, is the power of judicial review. And the power of judicial review is a part of the basic structure of the Constitution that cannot be destroyed or taken away through the amendments. So, this is the concept of judicial review. Now, we come to a very important question. Are all laws violating fundamental rights invalid? No. The answer is clearly no. There are certain laws that we term as saved laws under Article 13. So, the laws saved under Article 13 Clause 1 are pre-constitutional laws that are not fully void. Only the inconsistent parts are inoperative and valid portions continue. Then, laws saved by the constitutional amendments, that is due to Article 13, Clause 4. Constitutional amendments are not law as per Article 13, but that means they cannot even destroy the basic structure of the constitution. So, amendments can be made, but they cannot touch the basic structure of the Indian constitution. And the key case on this point is Keshwanand Bharti versus State of Kerala. Then we have laws saved by reasonable restrictions. Article 19(2) and 19(6) allow reasonable restriction. That means not every restriction that is imposed on the fundamental right is unconstitutional. Reasonable restrictions can be made even to fundamental rights, and this reasonableness is judged by the courts. So, even the fundamental rights can be restricted on certain reasonable grounds. So, these laws are what is termed as laws saved under Article 13. That means all these changes can be brought about, and these are not as unconstitutional, or these are not considered as inconsistent or violative of fundamental rights. So now we have here a quick table summary for all of you, where we have mentioned the doctrine, the core idea enshrined in that doctrine, and the most important case law associated with it. So we have severability, eclipse, waiver, prospective overruling, and the doctrine of judicial review with their respective ideas and case laws that you can go through. So, in the end, we can say that Article 13 is the guardian of fundamental rights. It enforces constitutional supremacy. Judicial doctrines ensure balance between individual rights, legislative intent, and constitutional stability. So, this is all about Article 13, all the important cases, laws, and the doctrines enshrined in it. If you would like to know more about the Constitution of India, do subscribe to my channel.